Hello again. Welcome to the ARM podcast with me, Abbas, Kazerounian, your host. We got a really special edition today because for the first time in ARM's history of the podcast, we've got two actual litigators that are what we call frequent flyers. We've got Marissa Temple and none other than himself, the main man, Justin Randall. Welcome to the show.
Well, thanks for having us, Abbas.
Thank you.
First of all, thank you for being on. I really appreciate your time. I know how busy you both are. And I mean, these are real trial lawyers, by the way. We were trying to actually schedule this for earlier, and Marissa was in a federal jury trial in Las Vegas. So, you know, these guys are the real deal. The first thing I kind of really want to get into from the litigator's perspective, because usually we get the mediator's perspective on the podcast, is what you as litigators are looking for in a mediator and a mediation entity if it happens to be like an organization like ARM. And we're going to do ladies first. We'll do the do's first, and then we'll do the don't. So Marissa, if you give me like what it is that you're looking for.
Definitely experience. I mean, we look at a lot of times the clients will ask, you know, were they judges? Were they litigators? Have they handled these types of cases? And so that's always important that we have someone that kind of has a history and a knowledge of the types of cases we're handling. Also, I think for ARM, it's something that we love, my firm loves, and the attorneys at my firm love. It's the demeanor. That goes a long way. I had a mediation earlier this week at ARM, and the adjuster loved the mediator. They clicked. And so a lot of times, if you have someone with a good demeanor, the client will take what they're saying seriously. They'll put more weight behind it. So the demeanor is important for us too.
That's really good to know. Thank you. And what about you, Justin?
I think kind of jumping off of what Marissa said, you know, with plaintiffs, most of my clients, they have a low education. They typically don't even know what the court system is, let alone how a mediation works, what a mediator is, or any of that. And one of the things that I've noticed about ARM, especially because I practice in 3 states pretty actively, so California, Arizona, and Nevada. And one of the things that ARM does is the mediators and the neutrals actually try and get to know the plaintiff. You know, they sit down before they have any discussions about money or the case or anything, and actually just talk to them and see if, you know, how they are as a person, who they are, what their background is, things like that. And, you know, when I've done it in other states, you know, Arizona or California, a lot of times the neutrals don't even want to talk to the plaintiff, which toward the end of a mediation, when you really need to have that relationship, makes it very hard to settle a case because they haven't built that rapport at the beginning. And so that's one of the things that we really like about any of the neutrals we've worked with at ARM. They all make a point of doing that, and they make sure that happens from the very moment they walk in the door.
That's really good to know. Thank you. And you know what's also a fine balance is that I've had experiences where I go to mediation and the neutral kind of overplays that, and they start getting their family albums out and showing you like, you know, baby pictures. And, you know, I'm like, okay, like, you know, like we're 45 minutes into this now, like, but I totally get what you're saying. And I think that's really important because I like, you know, I do a lot of litigation. I do a lot of mediation, and it's very important from the, you know, plaintiff side of the V that rapport is built. Now, kind of on the same path about kind of, you know, building trust in each of the rooms, and how important is it that the mediators, like, you know, reputation, for example, because obviously it's easier for ex-judges because of, you know, they've got the HON before their name than like experienced mediators, because, you know, when I go to a certain mediation, like I specifically look for maybe a judge sometimes because an institutional defendant is more likely to listen to them to get money on the table. But like from your perspective in your fields that you litigate, you know, like, you know, what characteristics are you looking for in a mediator specifically?
It's not always, I mean, sometimes the judges I feel like are the best fit for the case because they've been exposed to trials and they know what, you know, potential outcomes are and can kind of talk about the risks. But a lot of times I like attorneys that are, especially attorneys that have practiced both sides. I know there's some at ARM that have been on the defense side and some that have been on the plaintiff side. And even sometimes I like judges that have no civil experience. If I've got a case like a slip and fall is a perfect example. We have a slip and fall where liability is going to be the main issue, usually not as much damages. I want someone who is like a juror. You know, I haven't handled a bunch of slip and fall cases for the defense or the plaintiff. I'm just someone that maybe has a long history of criminal experience, and I'm going to sit there as a very neutral mediator and tell you what I think from someone that hasn't practiced in this area, and using their just general mediation skills, they're still able to reach a great result having no experience. So, you know, it just depends on the case, what we're looking for specifically. But, you know, sometimes judges are the best cases that are headed towards trial, and sometimes it's the complete opposite for us.
I totally agree. And to what degree, I mean, just to follow up on what you just said, I found it really interesting. Like you said, you know, maybe an ex-criminal judge would be good because they act more like a juror. But do you find that subject matter expertise is also an element in what you're looking for?
A lot of times I think it is. You know, like the one that I mediated today, that was a first party, potentially bad faith. It's pre-litigation, but you know, that's a very kind of a niche area where a lot of attorneys don't practice, and a lot of judges don't have much experience. So picking someone that really understands like the particulars of those first party cases is important. Otherwise, you're having to educate someone in a completely new practice area. So definitely, I think on a lot of cases that's important.
Yeah, yeah, it's very, very insightful. Thank you. And Justin, what about you?
Well, on the plaintiff's end, we exclusively want to work with mediators that have put O.J. Simpson in jail. We think it just is really the best for a personal injury case. It just works really well. But in all seriousness, for us, a lot of it is, you know, having the judge. They understand that they've been a judge. You know, looking at someone like Trevor Atkin, for example, he was a judge, but he was also a defense attorney for 25 years. You know, he knows how to speak State Farm. And so he can talk to State Farm or one of these other insurance companies like a defense attorney and actually say, look, you're weak on these 8 areas. Your case isn't as good as you think it is, which a lot of times is what's needed in a mediation. So at least from our end, we think that. I'm sure Marissa will debate that and say that the plaintiffs are always greedy, awful people. But,
Most of the time.
you know, I think that helps. It does help with my clients, at least, to say that Judge Glass put OJ in jail too, because they're like, whoa, that's crazy. Like, if you don't settle your case, she'll put you in jail too.
Marissa, do you speak State Farm?
Very well. I like to think so. That's my second language.
Nice. So let's reverse the order here. Let's go to Justin first. So what are the don'ts? Like what are your pet peeves that, you know, like, you know, if there's some mediators watching this, they're like, oh, maybe I shouldn't do that anymore. That, you know, upsets litigators and their clients.
I mean, I hate when a mediation's going nowhere and they push for it to keep going. Now, sometimes pushing for it to keep going does happen and does work. You know, I can think of a case that I had in Los Angeles where we were at like $100,000 for like 5 hours. And then I said, I'm walking out, and we got up to 1.4 million pretty quick. But that's not going to happen most of the time. Usually it's like, well, just come down. Let's try and get this done. And it's just a waste of time. If we know it's not going to work, let's just call it a day.
Yeah. You know, like, I do totally agree with you, like, on that. But then there are certain scenarios where you just got to, like, kind of go through the process and sweat it out. And, you know, like, I think it's a case by case. But if I find out that someone's just, like, messing around and going through it just for the sake of it, then I'm going to get peeved as well. So I totally, you know, sympathize with that. I totally agree. It's a good tip. Marissa, what about you?
Probably for me, I think a lot of the mediators in Las Vegas are pretty good about this. The mediators at ARM are good about this. I think it's helpful. The mediation briefs are confidential in almost in every case I've had. Binding arbitrations are a little bit different, but for mediations, we keep them confidential. So what is a little bit frustrating is if a mediator shares information with the other side without checking. And like I said, the mediators in Las Vegas are typically pretty good about saying, hey, can I run this by? But a lot of the stuff that I put in there is, you know, stuff I don't want the other side to know, or I plan to reserve, you know, for closer to trial, motion and eliminate type issues and stuff like that. So stuff that I think will help settle it from the mediator's perspective, but I don't necessarily want shared. So that's probably one of my biggest pet peeves.
Well, rightly so. I think that's a major mediation faux pas, in my opinion. I mean, that shouldn't happen. I mean, what are both of your opinions on certain mediators are kind of like swapping of briefs. And, you know, when I've been asked to do it, I sometimes send a more confidential one to the mediator, and then I redact the one to the other side, because I do see the benefit in it. But what are your positions on that?
I think it rarely happens in Las Vegas. I don't know that I've ever had it happen in Nevada. I've had it happen in California and Arizona, but not really here.
I think one way that it would help, though, and this has happened to me many times in mediation, is I'll get to the mediation and we will have a number of like the medical bills, the futures that's completely different than what the plaintiff has. And so right from the get-go, our authority is based on the wrong information. And so if I had a swap of briefs just for the basic case information, that might be helpful, because I mean, it's like countless times where I've walked in and said, okay, well, that's completely different than what I've told, you know, the insurance company or my client or whatever. So,
Yeah.
But a lot of times that's helped by, you know, at least at ARM, most of the time, you know, Justice Seda or Judge Glass or any of them, they'll call at least a couple days before and we'll talk about it. And if they see a disconnect, they'll be like, hey, what's going on here? They've got $1 and you've got 100,000. Something's off.
Right.
that's
Right.
helpful.
I think they do a really good job at ARM of being prepared, actually looking at the briefs before they walk in, talking to you, making sure that they're actually knowing what's going on in the case before you actually walk in the door.
Thank you. I mean, you know, that's a good transition though, Justin, as far as the, like, you know, going into pre-mediation calls and follow-up calls in case the case doesn't settle at the on the day. So like, how useful do you find, I mean, you've kind of already said, you know, pseudo answered the question. How useful are these pre-mediation calls? Are you getting irritated by them, or like, that's pretty useful?
I like them. I mean, I like them. I think I can usually then have a conversation without my client,
Yeah.
with the mediator, whether it's I have a difficult client or I have, you know, the defendant's crazy, the defense counsel's crazy, whatever. We can have that issue in a more confidential setting than when my client's sitting in the room staring at the mediator.
Yeah.
And that's, I agree with that. It's super helpful.
And what about post-mediation follow-ups? Like, you know, because obviously, like, sometimes, you know, you may leave not very happy because, you know, it fell apart or something. Is it a nuisance that the mediator is calling, like, hey guys, let's get back together, let's come back to the table, or, you know, try and, you know, facilitate something to basically get to a resolution, even if it's over a period of months? Or are you welcoming of those calls?
Well, that's where we gossip about Marissa, so I'm all in on that. More of that. But seriously, I think it helps. I mean, just because a case doesn't settle that day doesn't mean it won't settle. You know, I can think of, and this wasn't a mediation, it was a settlement conference, but just recently I had one where it was not going to settle and it was very clear, but the settlement conference got us there, you know, 30 days later, and we did end up settling. So I think it helps.
Very cool. And you're on the same boat, Marissa?
I am. I think the pre-mediation calls and the post-mediation calls help. For the pre-mediation calls, I think kind of like along the lines of what Justin was saying, I give my mediation brief to my client. So it is kind of nice to have off the record conversations with the mediator ahead of time and just say, look, like, I really need this case settled. It's not going in a great direction or whatever. And then for the post-mediation calls, you know, you get in that moment of mediation and you're heated and you're impassioned and you're, you know, you believe your argument and your position, and you're hearing all the negatives about your case, and it's a frustrating process and it's sometimes slow moving. So when you leave the mediation and you have an opportunity to kind of just, you know, sit on it for a while, that follow-up call helps, because you're removed enough from the process that you've had time to think about it and can, you know, readdress potential settlement. I like it, especially when it's within a short time frame of the mediation, but it's removed enough. So it's not like 6 months later. A lot of times that's not beneficial, but like 1 month later, 45 days later, it's perfect.
Right.
Well, and sometimes, you know, with ARM, like, you know, obviously you could tell Marissa and I have known each other for a long time. We work well together. We can get everyone to the call too. So it doesn't just have to be plaintiff, mediator, defendant, mediator. You know, sometimes we can get all on the call and be like, look, we know, what do we need to do to get this done?
Yeah.
And it helps.
I mean, I personally, from my own personal point of view, like I get very frustrated when I go to mediation and, you know, there's a lot of posturing and there's, you know, back and two before any numbers come out and it's already 3 o'clock in the afternoon. Whereas I find the pre-mediation call, you can narrow the issues down to what's really the beef here. Like, you know, where's the disagreement? Let's narrow it down and discuss just those issues rather than starting with this broad kind of, you know, area of conflict. And I think those pre-mediation calls really assist with that, from my experience, of course. And then everybody else is different. So something a little bit more kind of like not as material to the mediation process, but something that like I think certainly helps. When we designed ARM and kind of built the building out specifically for this purpose, one of the kind of the things that like I personally took away from going to different vendors around the country, because I have a federal practice and I'm all over the place, is I try to take the best of everything. And one of the things that I found is I want to be somewhere where I'm comfortable so I can be doing just concentrate on the mediation. And like one of the worst experiences I ever had was I had a big class action with a very well-known mediator, very, very well-known and very expensive, best part of $20,000 a day in Oakland. And he didn't even send lunch. And like, we had to go to Quiznos and get a sandwich. And like, and I was thinking, what does my 20 grand buy? And like, you know, like, do you find that those little, even though you're coming for the mediator, you like to settle your case, that's the prominent, and then like, let's not take away from that. That's, you know, the main thing. But do the little creature comforts help, like, you know, to make things a little bit easier, like, especially with clients and all this kind of stuff, and the waiting, I guess?
Yes. I mean, there's no other answer. There's a mediator in town, and he's not cheap, and he charges you $1 for a soda. There's no snacks. You don't take a break. Like, when your clients, at least on a plaintiff end, you know, they're not used to sitting somewhere for 8 hours doing nothing. So if they can go get a snack, they can get a drink, it helps. It kind of stops people from getting hangry. You know, I think it really makes a difference in the mediation.
Good.
I agree. It's one of my favorite things I look forward to is what treats are we going to have?
You know, we have major debates on our side of the ledger, the ARM, about what are the most popular snacks, what we should discontinue, and what we should pick up, and you know, so like, you know, it's a continuous conversation, but it's always great to get feedback onto that. Back onto something a little bit more substantive. Like, do you like? Because I know from the ARM's perspective, like, you know, we're always talking to the mediators about preparation, which I think you've all alluded to, which is like reading the briefs, getting to know if there's any exhibits attached, all of that. Do you guys spend the same amount of effort writing the briefs? Because when I used to do more personal injury, I remember a lot of people used to cut corners, and their MSC briefs or the statement of facts from their summary judgments would be copy pasted into the mediation brief, and it wouldn't really talk about the weaknesses. I mean, are you open, because especially if you're sending a confidential brief, are you open to sending your weaknesses and spending that additional time to be able to trust the mediator with all of that, the weaknesses as well as the strengths of your case in putting it forward in that regard?
I do. I mean, I get to bill by the minute, so it does help. But I mean, I really, mine are, like recently I've had to go back to the mediation confirmation email or letter and make sure I'm not breaching any type of page limit, because I do a very thorough, I think, brief. I want to put everything in there. So that you know, in advance, everything's on the table. And I do have a whole section on weaknesses, and it's not the generic, like, here's, you know, basically spinning a positive into a negative. I mean, it's genuine weaknesses, because I think that's the only way you can get a case settled, is if you say, look, I recognize that here's the issues with my case. If I didn't have issues, then, you know, we wouldn't be here. So.
Yeah. I think you have to be comfortable with the mediator, though. If it's a mediator that you don't know if they're going to walk and hand the brief to someone else,
yeah,
that could be a problem.
Yeah, I mean, it's a balance, right, with the trust of the mediator and kind of being too lackadaisical. Like, I agree with that. Like, you know, I kind of go about it the same way, Justin.
Yeah, but I mean, some of these mediators we've worked with for years. We know them. They've had lots and lots of cases on both ends, so they get it.
Of course.
I will say something from a defense perspective. I do my brief. I prepare that brief weeks in advance. So if the deadline is, 3 or 4 days before the mediation, my brief is prepared several weeks before. And there's a reason for that. It's because a lot of times for some of these bigger cases, they require more than just, the person I'm reporting to review and give authority. They have to go way up the corporate chain to get some type of authority. So I will say one of my biggest pet peeves in mediations, and this is more on the attorney side versus the mediator side, but when I get 3 days before a mediation or 2 days before a mediation, a disclosure with a life care plan for $9 million or additional expert reports saying there's all these futures or there's all these past bills. At that point, my adjuster already has placed authority on it. They usually have to travel to the mediation. So they're not looking at all the new information days before. And really, frankly, I'm not looking at the file either. So that's been something that's to me something for the briefing portion that's important to keep in mind.
Interesting.
Marissa, you're a gunner who does their briefs weeks.
Oh, that's a huge pet peeve, and you're probably one of those that just throws new stuff, don't you?
I do it just to annoy you because I know after this many years, it just
now everyone's going to do it.
Send you a disclosure day before the mediation.
Just sandbag a Randall. So, kind of in conclusion, I'm kind of really intrigued to get your perspective. Now that we're coming out of the pandemic, right? I think we've all got used to the Zooms and the blue jeans, mediations and court appearances. Is it, from your perspective, and if you had your way, something that's going to remain in the mediation of your cases, or are you guys, I want to be there in person? Or how do you view this moving forward from your perspective and the way you want to move forward if you had your way?
I love it. I mean, I think, as a plaintiff, sometimes my clients don't live in Las Vegas and it's hard for them to get back for multiple days at a time. It's just much easier for them, or they're hurt, they're not mobile. To travel is very difficult sometimes, even if it's locally within town. So I think it's great. Plus you can mute people, have conversations. I'm happy with it. I hope it never goes away.
I don't like it at all. I want in person all the time. And the reason why is because I think it's a lot harder for someone to say no in front of a mediator in person. And, you can, when you're removed, you can say, I'm not taking it, or I don't agree. It's a lot harder when you're there in the moment, I think, to say no when money's being offered. And so I think I like it in person. And same for the defense. It's a lot harder to say, no, you need to put this additional money on the table for an adjuster when they're sitting right there in front of the mediator. On the phone, it's a lot easier to just say, I'm not doing it.
It's really interesting that you say that, because I personally, I like to be there in person if I have my way. But looking at it from a plaintiff's perspective and what the defense is doing, if the defense is there with the adjuster, I love that for the exact reasons that you just laid out. But one of my personal pet peeves is 2 o'clock comes and I got to get a plane back to Texas. I'm like, we barely started. Where are you going? And so, but if they're there on Zoom or Blue Jeans or whatever it is, we have Blue Jeans at ARM, as you know, they don't have that excuse, but it's easier for them to say no. So it's a coin toss about which is the lesser evil. And I don't have the answer to that, but it's interesting that you both have a different perspective on this, which kind of shows we don't really know where this is going to end up. But I do agree with Justin that it's at least some semblance of virtual hearings and mediations is there to stay.
Well, the problem is Marissa's a boomer and I'm a millennial, so it's just
operated.
Culturally very different for us.
Are you going to take that, Marissa?
I'm not. And I will say I had a virtual and an in-person this week, and they both settled, so they can both be effective. I know Justin just wants to see my face, so
Boomer.
He wants to be in person.
Oh God. Anyway, well, any other thoughts or tips or anything before we conclude?
I mean, I just love that all the neutrals were very scared yesterday when I was going to say on this podcast about them. There were multiple of them very nervous. So I won't name names, but some of them were concerned.
Yeah, I have a good idea of who those people are. Well, honestly, I just really want to thank you for giving up your time and giving me such great insight and giving the viewers and the listeners such great insight. And obviously thank you also for being you and always being at ARM. Really appreciate you for everything that you do and appearing today. Thanks a lot.
Thank you. We appreciate it.
Great. So until next time, stay safe, everybody, and we'll see you soon.